I want to thank you guys for joining us on this snowy day. Um, as a lot of you may know, we over here in the Division of Research and Economic Development are very interested in expanding activity in the intellectual property, technology transfer, and commercialization space. And so, with that in mind, we have partnered this year with Tremonti Consulting to help provide some capacity here at Virginia State. And so, they're going to do a little bit of, I guess, professional development with you guys today as it relates to intellectual property and technology transfer, with a particular focus on agriculture, food systems, and environmental science and extension programs, but certainly with things that can be applied across the academic space. At the end of this, I will come back on and talk to you guys a little bit about sort of where to find some of this information here at VSU. But for now, I present to you Dr. Julie Nagel.
Hi, thanks for having me. And this is very informal. So if you have any questions as we go along, please feel free to ask. Um, and as you just heard, we're going to hear about intellectual property. And I made this presentation specific to your college and all of the examples therein. Let me see. Does it like me? There we go. Okay. So we're just going to start with the baseline. Why IP matters as for faculty, especially in ag, that you create a lot of real world solutions every day in your lab. Um, and that's what intellectual property is, right? It's a vehicle to translate those ideas to the public for greater good. And that feeds directly into the land grant mission of Virginia State. Um, so it can protect the research that you're doing in your lab. It can increase the competitiveness of the work that's going on. And also there's a monetary piece of this too, that once you license intellectual property, that typically comes with a revenue stream and the opportunity, of course, to translate through startup companies. So who we are. Tremonti is a consulting firm that rolled out of Deloitte over 20 years ago. And we focus specifically in this space, helping mostly in universities, but we have a healthcare practice to evaluate their intellectual assets.
Good morning. I was up here. Sorry about that. Okay. I usually not.
We look at the whole gamut of discoveries, all the way through protection, partnering them with industry, helping with startups, that whole gamut of translating the research at a university to the real world for products and services. So that's where I have we have a work with about 200 institutions across the country and a few international. So today we'll talk about types of intellectual property. There's 4 different types of intellectual property. It's not just patents. There's also trademarks, copyrights, and trade secrets. And these 4 types are used in different ways. And sometimes one invention might be protected by a patent, the brand name protected by a trademark, and the software protected by a copyright. So sometimes they're used as a package as well. They're all different in how you obtain them, and they're all different on how long that protection lasts for. A patent gives you 20 years of a monopoly to use the invention, whereas a copyright is the life of the author plus 70 years. So they're very different. In some examples, a patent would protect an automatic irrigation sensor. So something that has utility in that way as a process or a device. Whereas a trademark would protect a name, like Vidalia onion is a protected trademark. And copyrights are more for software, training materials, curriculum, that sort of thing. And then trade secrets are something you don't want to publish because patents do publish and copyrights do publish. So if you want to keep secret your proprietary feed additive mix or an algorithm for farm yield production, something like that, you just don't tell anybody about it. You don't publish it and you keep everybody under strict confidentiality agreements and just keep it to yourself, like the formula of Coca-Cola has been a long-standing trade secret. Typically, universities have more activity in the patent realm than the other types of intellectual property. And there's three main types of patents. Utility patents protects all new and useful inventions, that's processes, machines. Plant patent is protects plant varieties, except they don't deal in potatoes, but tubers. But everything else, new varieties of plants are protected by plant patents. And then there's also design patents that protects the ornamental look of an object. So if you think of an iPhone that has curved edges and Android phone has square edges. Well, the round edges is protected by a design patent. So the Samsung phones have to look different. There's also something called PVP or plant variety protection certificates that the USDA issues. Those provide IP rights for new sexually reproduced or seeded plant varieties and tubers. And that's a unique mechanism to plants and it enables licensing of new varieties to companies. So that's another tool that we can use when there's new plant varieties. So just to give you some ideas of what IP might look like in the agricultural field, of course, plant varieties, but also new fertilizers, amendments, soil treatments, sensors, devices, food processing technology, animal health tools, and also extension tools and decision support methods. There's been a lot of work done in new curriculum and new outreach materials and that stuff type of area and extension that has had commercial relevance as well. So as you go through and think about your research and think about, well, is what I'm doing in what I'm doing in my lab and what I'm thinking about, what I'm writing, does it have any commercial relevance? And should I look, how do I look at my body of work in that way? Come back to these slides and I hope these can help kind of help you look at your research in a different way through a lens of how could I translate this to the public outside of publishing? Because publishing is a method of commercialization. Of course, it puts it out in the public sphere. But how could I bring benefit back to Virginia State and you personally through going a different route to get your work into the hands of a company that can make new products and services? So this is another list of things that you could that are going on in ag right now. So just to kind of help you think about, well, that's kind of what I do. I should think about this world as well. So there's certain standards to be able to have a patent granted. It has to be new, which means new work, which means it can't be publicly disclosed already. So that's really important as you think about publishing and giving talks and doing public field days at the extension center, you know, different things like that where you're talking about your research to a public audience. Once you do that, the clock starts ticking and you only have 12 months from that disclosure to be able to protect your idea with a patent. And you can't do anything internationally once you disclose it. So just remember that talking to us about your research, we're not going to slow down your publishing, but we could be on a parallel track of getting it protected with a patent at the same time. So it has to be useful, it has to have real benefit. It can't be obvious. So if you're putting two things together to create A plus B equals C, and that's obvious, you're not going to get a patent on that. So a non-obviousness is the bar that they use. And it has to be fully described. You can't hold things back. Basically, a patent is a user manual. You're teaching other people how to use your invention. So what's not patentable? Naturally or non-cultivated plants are not patentable. Traditional agricultural methods, hydroponics, as you see there in that picture, you can't patent hydroponics. Plant propagation methods are not patentable, and somehow they have a carve out for tuber plants that are not, you can't get variety plant patents on those. And obviousness modifications. So if you're just changing one thing, and it's obvious that that could be a change that would be something that one would use, you can't get a patent on that either. So we'll switch now to copyrights. Can protect all sorts of things from training modules, curriculum, videos, different images, field trial databases. You know, data has a lot of value now in the world of AI. Extension materials could really benefit from copyright for wide distribution. And not always are you planning to make money off of that? That's not what we're talking about. We're talking about telling the world this is Virginia State's property. And trademarks. Trademark protects the name, your logo, anything that identifies your product. So if you want to name a cultivar that's a VSU developed cultivar, you could get a trademark on that name. Any kind of signature extension programs you might have, anything that you want to do to build recognition for VSU that could help you with your outreach and adoption of that particular product would be applicable to a trademark. And trade secrets, anything that you want to keep proprietary, that you don't want to share, that you don't want to be published. So if you have a unique formulation for soil blends or a processing technique or some kind of algorithm for precision ag analytics, your supplier partner list, a data set, all of that you could just keep proprietary, and you can license trade secrets to companies, but remember it's only protected if it's not disclosed. So if your graduate students, you know, is out talking about it to companies, then you don't have a trade secret anymore. And there's nothing in the government that stands behind this and gives you any kind of protection. So you have to make sure that's tight within your own group. So tech transfer at Virginia State, created to support the land grant mission of the institution to move those innovations in ag science and other parts of the university to the public, and enables licensing startups and partnerships. And here to do all that work on your behalf. You don't have to do any of that on your own. We just partner with you and let you be the technical expert therein, and we do all of the sausage making in the background. So this is really an extension of what you already do. You deliver innovation to farmers, communities, and industry already. This is just a mechanism to do that. That can bring some financial return back to the institution and to you. So how does tech transfer work? It starts with the idea that you have, the discovery, and then you tell us about it. And we call that a disclosure. And we'll go more into what invention disclosure is, what it's a form, what it looks like, all of those things in the next couple of slides. So basically you tell Tech Transfer Office about your invention, and then we look at it from a market perspective. We ask questions like, could we get a patent on this? So that is a search of the patent literature to see if other people have already protected an idea very similar. And then we ask the question, should we get a patent on this? Is there a market opportunity out there that any kind of market pull that someone would want this as a product or a service? The answer to the two of those questions is yes. Then we work with external patent counsel to get IP protection, whether it's a patent, PVP, or a copyright, trademark, any of those other types of intellectual property that we talked about in the previous slides. Then we say, okay, what companies would be interested in this technology? Who should we reaching out to? We put together all that material. We work with you to make sure that's correct. And then do marketing campaigns. Send that information out to companies to get interest. And so the end goal, of course, would be to license that to a company or to give them rights to commercialize it or help in forming a startup if that's something that you would want to do. So Tremonti, me, partners with you at every one of those stages. That's nothing you have to learn and do on your own at all. You're there as the technical expert. And remember that faculty retain a share of any money that comes in after licensing per the institutional policy. So why do you want to disclose your ideas to us? We can talk about protecting IP rights before you do any demos or field days or present any abstracts or publish. So we could talk about options. If you have a discovery in a federally funded research project, the government wants you to disclose it, and you have to do forms when you're closing out your grant saying whether an invention was conceived or not during the time of the grant. We want to make sure whoever discovered that we have that correct, because inventorship is different than it's a legal definition of who conceived of the ideas. It's not like a paper where you can decide who goes on the paper. Inventorship is a legal type definition. And in a lot of federally funded grants, they want to know that you have a history of translating your research into the public. So it kind of gives you text and fodder to demonstrate that you have done that in the past. So again, talk to us before you're presenting any results if you think you've made something that would have commercial value. And we can help you, of course, determine that as well. So did I invent something? Should I disclose it? You don't always look at your research through that lens, but I would encourage you to. Have you created a new plant variety? Do you have a new tool or sensor that you're working on? A new food formulation, a unique soil treatment, any kind of machine, process, or device, or if you're doing any software or models or decision support tools, any kind of curriculum, or anything that you're working on that's new and innovative in your lab. Tell us about it, and we can help understand, is this something that the path we should go down or not? So the